Madam, with your kind permission, I beg to move statutory resolution.
Yes. That's all. That's all.
That this House disapproves of the Telecom Regulatory Authority of India Amendment Ordinance 2014, number 3 of 2014 promulgated by the President on 28th May 2014.
Yes, thank you.
Madam,
Mr. Minister. No,
Madam,
you have only.
Madam, better you should treat it separately. Madam, our honorable law minister is an eminent person. He can deal everything.
You can speak
by simply twerking his nose, he can deal anything.
I have already declared it. Please, Adhir Ranjan.
So better,
Minister, yes.
if minister will. After my deliberation, he can easily respond it because he is so competent and eminent personality in the Council of Ministers. He is an eminent lawyer. He can do everything, madam. Madam, we have nothing personal agenda with any appointment in this government. But the fact is, the way the government has been transgressing the domain of legislature is a matter of serious concern. The fundamental question is whether legislature will prevail upon executive or not. Yes, there is a galore of instances where ordinances were issued since the independence. But when our honorable Prime Minister was seen bowing down to the temple of democracy, he should not be seen in kowtowing his ego by resorting to an ordinance route. This is my humble submission to this government, because heaven would not have fallen upon you had that appointment been done through the regular legislative way. You are an eminent lawyer. Even you happened to be the member of Joint Parliamentary Committee for examining the telecom scam, and you are that party stole this house weeks together for the constitution of JPC, and that very tri-chairman was examined there. It is your government. It is NDA government in the year 2000 has amended the Tri-Act to rule out the appointment of regulators, chief regulators in any central and state government. So now the question is that the day the person was appointed, he was not at all qualified for that appointment. But in spite of knowing the statutory disqualification of the same person, what had warranted you to bulldoze the golden path of legislative procedure that needs to be considered upon? Not only that, it was conceptualized and passed in a lightning speed, smacking of a little hidden agenda. May I know whether the PMO was unaware of the statutory hurdles of that appointment? And once it was highlighted, you did not want to eat the humble pea and resorted to the ordinance route, and through this way you were liable of trampling upon the golden path of democracy and resorting to the outrageous path of ordinancocracy. Your government had set out its legislative journey by way of ordinance. This would not augur well for any democratically elected government.
Yes, Adhir Ranjan ji, you can address the chair. Why you are directly attacking?
Oh, no.
Attack through me.
Achha. Madam, I cannot have the courage to attack you. Ore baap re baap. I do not want to be rusticated from this house.
Address the chair. Yes.
Achha, madams,
Yes.
may I ask, should an ordinance be restored to appoint an individual for a post?
Yes.
Is it admissible? I do not question for an integrity or honesty of an individual. We have never opposed, we have never cited the issue of integrity. But only integrity cannot be the sole criteria for promulgation of any ordinance. Should an ordinance be issued to overturn the intents of the legislation? Again, I am highlighting the intent of the legislation enacted in the public interest. The legislation was enacted in the public interest because the intention was to prevent any quid pro quo. The intention was to prevent any nepotism. The intention was to ensure transparency. Should an ordinance be issued to overturn the intent of the legislation enacted in the public interest? Madam, it could be the first instance in the annals of Indian legislative institution when a government of the center promulgates an ordinance even before proving its majority on the floor of the house. However, incidentally, I know, however, it is incidentally, you objected any kind of ordinance brought by UPA government, for example, food security, for example, anti-corruption legislation. But here, forgetting everything, you have introduced your maiden legislation through ordinance. Maiden legislation through ordinance. Advani ji also here. He is also father of this house. I think he also opposed to this kind of way being followed by this government. Madam, I am, madam, simply drawing the attention of this house and my honorable minister that this kind of ordinance should not be brought in such a way. We are not against ordinance per se, but the way one individual has been preferred to offer an appointment to the ordinance route cannot be substantiated by any argument whatsoever. That is why I am opposing vehemently to this kind of legislation being brought through ordinance, and I would hope that reason will prevail upon this government and they will shun from pursuing this ordinance route, because ordinance can be promulgated only on extraordinary situation. You cannot substantiate of what kind of extraordinary situation was arising out which warranted you, which called for this kind of ordinance. So I hope that this government will reconsider and will follow the formal legislative way to appoint any personality. Madam, they may refer that, madam, just last minute, madam, they are referring that other, financial institutions are there where this kind of restriction had not been imposed, right? But we are not preventing you to bring the same legislation for all the regulators, the competition commission chairman, SEBI chairman, etc. You are referring that there is some provision for other regulators which is not available in the tri case, but nobody has prevented you from bringing the same legislation on par with tri. But you should not resort to this kind of ordinance by simply on the pretext of pretext of other regulators. So your intention is very obscure, and that is why vehemently am opposing this kind of legislation. Thank you.